there's a reasonable chance that many people have been wrongfully convicted over the past 15 or so years in this county and nationwide. And so that's really why we're here today, is because of the potential for wrongful convictions. I see we've got some folks, I assume you all practice criminal defense. Anyone get a letter from the DA?
Yes.
Anyone confused about the letter?
I have some questions, yeah.
Okay. Well, hopefully it's a deep issue, so really we're just going to skim the surface today and comb over sort of the main issues. And at the same time, I'll sort of tell the story in my case and how that went down, and contextually, hopefully that'll kind of shed some light on it. So the goal of the presentation basically would be to help you identify potential cases that you've worked on in the past, because that'll be the bulk of the presentation. Then I'm going to give you some pointers about how to respond appropriately to the Dear Counsel letter based on my interactions with the district attorney's office, which has been, to be honest, has been a mixed bag. I certainly respect the process, but at times I've certainly been disappointed in the district attorney's office. I'm sure if we have criminal defense attorneys, you'll know exactly what I'm talking about. Here's the issue. For about 8 years, the San Diego County Police Crime Lab was basically, and the Sheriff's Crime Lab, although the case that I worked on involved only the San Diego Police Department Crime Lab. But they were inappropriately interpreting complex DNA mixture samples in such a way to basically over-include people and also to overestimate the possibility of a match. So the way that DNA interpretations work is it's a two-step process. And forgive me, I don't know what everybody's background is on DNA, so I'm going to just pretend that you don't have any background. And sort of, if you already know this stuff, well, you'll learn it again, I guess. In a DNA comparison, it's a two-step process. The first step is for the analyst to determine whether or not the suspect profile is a match, or what they say, the language they use is, are they a possible minor contributor or a possible contributor? In this case, we're talking about minor contributors in a mixed sample, but that's kind of getting too deep there. The question is, are they a match? Does their sample match crime stain sample, the sample that was developed from evidence in the crime? And then the second step is to associate a probability statistic to that match. The old way of doing it was to use what's called the CPI or CPE, which is the combined probability of inclusion or combined probability of exclusion. And basically, what the crime lab was doing is there were many folks based on their interpretation, methods that should never have even been included as a match in the first place. And then there's a second step where even if it was appropriate to include a random person as a match, nonetheless, the CPE statistic overestimated the probability of a match. So that could have happened in one of your cases where, best case scenario as a defense attorney is to find out now that they were inappropriately included. But even if they were appropriately included, if the probability statistic has gone down substantially, say from 1 in a million or 1 in a billion or some number like that, down to 1 in 20, 1 in 30, 1 in 40, then that also could be a material fact that affected the outcome of the trial. So that's two things that you really have to look for. So let's define some terms. I have here a complex mixture, okay? And basically a complex mixture is, both of these are crime stains that were analyzed for DNA. They came from gloves. Both of these are complex mixtures. It's kind of blurry, but what these are numbers, and they're called alleles, okay? I'm sure some of you probably know this already, but every allele in a crime stain comes from a person, and each genetic marker has 2 alleles per person. And the way that works is, at every genetic marker, if you took a reference profile from any one of us and you tested each genetic marker, and there's billions of genetic markers, And in the San Diego Police Crime Lab only uses these, 13 or 14 or so for identification. You'll get an allele or a gene from your mom and an allele or a gene from your dad. So every single allele has a sister allele because you have two sources of the allele, the mom and the dad. Some folks have the same allele at the genetic marker. So if you test, let me just skip forward to show you what I mean. This is a reference profile. It's blurry, but it's a reference profile. So this is a single source profile taken from a person. And you can see at this genetic marker here, they only have one allele. What that means, it's not really that they only have one allele. They just got the same allele from their mom that they did as their dad. So that allele represents two alleles. When the DNA analysts look at that data on an electropharogram, they can't distinguish it as two alleles. They just see one allele. But we know, based on sort of the science involved, is that they got two alleles from their that were the same allele from their mom and their dad. So we'll go back. So what makes it a complex mixture? Because this is how you're going to identify a case. If a case you had involved a complex mixture, then that's potentially a case that needs to be reviewed. And a complex mixture is basically 3 or more individuals were all mixed together in the sample. So in the case of gloves, which this is gloves, if I put on a pair of gloves, or earlier I shook Joe's hand, and that's another issue, transfer DNA. I shook Joe's hand, I put on the gloves, somebody else puts on the gloves, and then you swab the gloves and get genetic material. You're going to have a mixture of genetic material from 3 people. The way we know how many people are in a mixture sample is basically we take the genetic marker that has the most alleles and we divide it by 2. And that's the minimum estimated amount of contributors. And so in this particular case, we don't need to search for them. It's probably this marker here. 1, 2, 3, 4, 5, 6. This one has 1, 2, 3, 4, 5, 6, 7. So this 7 divided by 2 is 3.5. So the minimum amount of contributors is 3. And that's how that works. That means it's a complex mixture sample. Now, the other issue is when most of the data or some of the data of the alleles is in something called the stochastic range. Okay? So the stochastic range is essentially, let me break this down because this is sort of some background. But basically, it's low-level data. It's because of enhanced detection methods or just less DNA from another individual in the sample renders the data to be of less magnitude, is the best way to put it. So I'll give you an example. In my case, the gloves were soaked in blood. And when they swabbed the DNA, the mixture samples, you can see all these alleles that don't have a WK next to them. And those are, I know this is blurry, so I apologize for that. But this is a WK. WK, that means weak. These don't have a WK, these top ones. The analyst is able to look at the electropharogram and separate out the major component and the minor components. So the analyst will look at this and say that these peaks on the electropharograms are substantially higher than the minor peaks. And you can see that here. This is like a chart of an electropharogram. So these two on the right, or on my right, your left, would be major profiles, because you can see they're very high. And the peaks all the way to the left here are very low peaks. So these would be minor profiles. And the peak ratio between the data, you can sort of resolve, which profiles are which. So if all the peaks are from a major profile, you can pretty much be confident that those peaks are from one person. And all the peaks that are minor profiles, you can pretty much be confident that those are from a separate individual. But what happens in a lot of cases, and happened in this case, is that the major peak can be separated out, but all the minor peaks are all similar heights. they're all about the same magnitude on the electropherogram. So the analyst can't resolve which peak came from who. Like the analyst can't say, well, this 17 and 17 came from the same person. They simply just don't know the answer to that question. So when the peaks are low enough, which they were in this case, they fall into this region called the stochastic region. If you see on this chart, there's a red line and a green line here. Okay? Peaks that go above the stochastic region, we're confident that those peaks are not only real peaks, meaning not stutter or some kind of artifact from the process, but they're also paired with a sister allele properly. And the way that works is because in the stochastic range, let me define some terms. And sorry, I know this is confusing. I'm trying to make it simple here. This line here is called the detection threshold, this red line. The detection threshold means that the analyst, unless the peak goes above the detection threshold, the analyst is going to disregard it. So it's not going to be considered in the profile. See this mixture profile. It's just not going to be considered in the mixture profile if it doesn't make the detection threshold. If the peak goes above the detection threshold but doesn't make it to the stochastic threshold, which is the green line, then the peak falls within the stochastic range. And there's a fear among analysts that if the peak didn't fall, that if there's peak is in the stochastic range, that its sister allele is present, but it didn't make it above the detection threshold. That's a legitimate fear. It's called allelic dropout. Okay? And that's what I have here. For unknown reasons, an allele is not detected. So the way that plays out in a sample is what right here on this genetic marker we have an 11, a 12, and a 10 allele. The 10 allele is weak. And it may be in the stochastic range, I haven't checked, but let's assume that it's in the stochastic range. If the 10 is in the stochastic range, then we don't know if it's a complete profile at that genetic marker. There could be a sister to that 10 that is being disregarded by the analyst because it didn't make the detection threshold. Is everybody following? So that's when you have, in this case and in many cases in San Diego, they develop these PCR, they use the PCR process, which is the process where they make the electropherograms which they read and interpret. They get genetic material, and most of the material, in this particular case and in many cases, most of the material is in the stochastic range. In fact, in this case, more alleles are in the stochastic range than not. And so for each allele that's in the stochastic range, there could be missing data. There could be a missing sister allele that did not make the detection threshold. This whole concept of allelic dropout is the entire reason for the misinterpretations of the guidelines.
So if it did detect that additional allele, would that mean it probably would go above the stochastic range and give the person analyzing it a more confident read on what's in there? I'm just trying to, like, if the allelic dropout occurs, that means that they're not detecting a possible DNA that could be there, but they're disregarding it?
They're disregarding it.
Okay.
So they're probably detecting it and disregarding it. So you can check the electropherograms. And that's a great question and a complicated question, because when a lab decides to set its interpretation procedure, it does a series of validation studies. And one of the things that the lab establishes during their validation studies is where they're going to set their detection threshold. And that's based on a number of different factors that I really can't go into right now. But they decide based on empirical data, they have a new PCR kit that they're using, and they set a detection threshold. That becomes a bright line as to what alleles they'll use and what alleles they won't use. The analysts can still see potential data under the detection threshold. The problem with them using that is a concept called allelic drop-in, which is the opposite. Allelic drop-in occurs when you're using sort of stutter peaks or contamination or just noise above baseline that isn't an actual allele. It's just noise or some other contaminant. And the reason they can distinguish between legitimate alleles and baseline noise is by setting a detection threshold. And the data that we're talking about are the peaks that do make it to the detection threshold, but just barely. They're just barely above the detection threshold. So we're confident enough that they're legitimate peaks, but not confident enough that a sister allele that it pairs with is underneath that detection threshold. And since the lab set its bright line, detection threshold, they are unwilling to use a sister allele or potential data that's under the detection threshold. And so there's nothing wrong with that approach as far as we're concerned, except when you do some of the things that they were doing thereafter, which I'm about to get into. So that's basically the setup for, geez, I was afraid I would go too fast and be done, but now I'm like, well, I'll have enough time. That's basically the setup. It's when low-level allelic data, when it's so close to the detection threshold that there's a legitimate fear of allelic dropout, that we're not considering sister alleles that pair with one of these alleles. So we have these complex mixtures, and they do a comparison. They have the combined probability of inclusion, and this is what they used to do back from 2003 to 2011. They would take a reference sample, and they would note if the reference sample, say a suspect sample, if that sample had alleles that were shared with the mixture. And it's just as simple as 13, 14, okay, or whatever that is. These are both in there, 14, 13. 10, 31.2, 30, they're in there. I've highlighted the ones that are not in there, that are inconsistent. For example, this genetic marker has a 9, and this one does not. So it's actually inconsistent. Now, if the person that you're comparing is a donor to the mixture sample, then the appropriate assumption is that he will be or she will be represented at every genetic marker in every allele. Otherwise, they should be excluded because they're not represented. If you donated your DNA should be there. This 9 and this 18 aren't there. But the San Diego Police Crime Lab considered this a possible inclusion, notwithstanding the fact that the person's DNA is not found in the sample. And that was inappropriate. And the reason why is they were doing suspect-centric interpretations. This is kind of getting in the weeds. Am I still in camera?
I'll just go slide up.
Okay. So can you see? So basically, what a suspect-centric interpretation is when you infect cognitive bias into the interpretation by showing the analyst what the reference sample is first, before the analyst makes a determination as to what genetic markers are suitable for comparison. So, because of the problem of allelic dropout, the analyst would normally go through a mixture sample and determine which genetic markers he suspects or she suspects allelic dropout and not consider that marker because it's inappropriate. It might be missing data. The combined probability of inclusion requires a complete sample. Without a complete sample, without complete data, it's a useless statistic. So the analyst would work through this and say, this genetic marker, this genetic marker, this genetic marker, those are inappropriate for comparison because we suspect allelic dropout. So we're going to pretend we're not even going to look at those. We're going to omit those from our analysis, both for the mixture sample and for the reference profile. But the police lab were not doing that. In fact, they were looking first at the comparison between the reference sample and the genetic marker, and then eliminating genetic markers based on where the inconsistencies were. So you're essentially choosing which data to consider, and the basis for your decision is who, in fact, you want to match to the profile. So in this particular case, I'll show you an example of this. This is a little bit blurrier than it should be, but I can show some of you guys who are here how amazing this is. But basically, in this first paragraph, it says that, right here, it says excluding the FGA marker. So for this is a particular person, and he's telling you that he made a comparison and associated a statistic. That says 1 in 450 in the U.S. population right there for this person. But he's excluded the FGA marker, which is one of the markers that the person is inconsistent. So then he moves on to the next person, and he's also included that person as a minor contributor. But he's excluded the CSF1PO, and that's what that says. He's excluded this marker, and this marker, which are D2S1338, D8S51, and the FGA marker. And then you go down to the next one, and this is another person, and he's now also included as a possible minor contributor, and the person has excluded, the analyst has excluded even more genetic markers that are listed here, and I know you can't see them because it's blurry, but this is a genetic marker. This one. It looks like 1, 2, 3, 4, 5, 6, 7, 8, 9 genetic markers are excluded. So what the analyst did is for each separate reference profile, they've used a different set of genetic markers. And that decision is made primarily on the information they get when they look at the reference profile. Okay, he's consistent here, but he's inconsistent here, so I'm just going to exclude that from my analysis. Well, this was found to be just a gross deviation from proper science, and I think it's obvious that this infects the process with either conscious or unconscious cognitive bias, which is something we all need to be aware of in genetics and in forensic science, right? Basically, this is the paper that states it. This is the forensic journal article that states it, I think, most succinctly, but there are tons of material out there that discusses this exact issue. There's, since 2008, when this first issue was first observed by Bruce Badoli, who's a forensic scientist in DNA, there's been probably 24 other articles, and if you want more fuel for this fire, I can give it to you. But basically, this is the quote that I picked out. Recent discussions on a forensic discussion group highlighted the prevalence of a practice in the application of inclusion probabilities when dropout is possible that is of significant concern. In such cases, we are aware of an unpublished practice involving calculation of an inclusion probability only for those loci which the profile of interest, hereafter the suspect, is fully included among the alleles present in the crime scene sample, and to omit those loci at which the suspect has alleles that are not fully represented among the alleles in the mixture. They go on to state that this policy is unsupported, and that it's basically false, and it's not a conservative approach, obviously. As you can see, and I'll go back a couple slides, and what happened to my client is that based on him being inconsistent at 2 genetic markers, he should have been excluded. Instead, he was included, and they associated a CPI statistic with him, which was presented to a jury.
The first code is 309. The first code is 309. The first code is 309.
So then the next issue is just simply using using alleles in the stochastic range, or genetic markers that contain alleles in the stochastic range. That practice has also been repudiated by the forensic community, and that one's a little bit easier to understand. It's simple. If you have a genetic marker and any of the alleles, other than the major alleles and the major profile, since it's been separated from the minor profile, it counts as a single source profile, which is still the most robust identification process in human history. Other than that, if you're talking about just the minor profile, if any of the alleles are in the stochastic range, it makes that genetic marker inappropriate for comparison. And in this particular case, we went through it during the habeas hearing, and I don't remember exactly, but virtually all the alleles you see are in the stochastic range. And so the entire mixture sample was inappropriate for a CPI statistic. But they calculated one anyway, and that was in 2000. The casework was done 2010. Swigdam promulgated, and I've cited this paper here to, again, there's lots of literature out there, and I'll make these documents available, that talks about this issue of using alleles in the stochastic range, how it's been repudiated, how it can't be supported. This one specifically says that this paper sets forth a set of best practices for interpreting mixture samples, and then warns don't use these practices in when the alleles are in the stochastic range, because it's just not reliable. So there's more papers on that as well. So let's get into the story of the case and how it went down, and basically that might help you identify cases on your side and what the issues will be. Swigdam came up with some rules about this in January 2010. Swigdam is basically the working group that advises the FBI on DNA interpretation and testing quality assurance standards. Basically this is on their website. This is what they do. This is their game here. Their guidelines are not mandatory, so that's one of the reasons that the San Diego Police Crime Lab didn't initially follow the guidelines that address these two issues, is because they were considered, just guidelines, just suggestions. However, as we'll go through later, these suggestions were adopted by the accrediting agencies thereafter that accredit crime labs to use CODIS. This is the first rule that was promulgated in January 2010. And it basically says the laboratory must establish guidelines to ensure that, to the extent possible, DNA typing results from evidentiary samples are interpreted before comparison with any known samples other than the assumed contributors. So that's the issue we were talking about first, that the mixture profile has to be evaluated for which genetic markers are suitable for comparison prior to the analyst making a comparison. If the analyst makes a comparison and then decides which genetic markers are suitable for comparison, the entire process is infected with cognitive bias. And we saw examples of that earlier. The second rule is, again, what we went over. Basically, when CPE, which is combined probability of exclusion, with no assumptions of number of contributors, to calculate the probability the randomly selected person would be excluded or included as a contributor to the mixture, loci with alleles below the stochastic threshold may not be used for statistical purposes to support an inclusion. In these instances, the potential for allelic dropout raises the possibility of contributors having genotypes not encompassed by the interpreted alleles. So the reason for this rule is really simple. When you have alleles in the stochastic range, for the most part, you're quite certain that it's an incomplete profile. And the calculation of the combined probability of inclusion requires taking into account all data. And so if you only have partial data, the CPI will overestimate to a very significant degree the odds that the person is a random match. Okay? The CPI is an important statistic for the jury because the CPI purports to give the jury an idea of what the weight of the evidence should be. So the CPI would tell a jury, for example, in a 1 in a million case, if you chose, the CPI asks, what are the odds that a person chosen at random will match the mixture sample just by pure chance? Because we know these alleles occur frequently in the population. All of us have shared alleles. So if you take a mixture sample and you compare it to a population, and let's say we have a true CPI statistic associated with that mixture sample, and let's say that mixture sample is 1 in 10,000 people will match by pure chance. Well, in a population of 1 million people, you just divide 1 million by 10,000, and what is that, 1,000, I think? I don't even know what it is. But whatever it is, that's how many people in our community will match the sample by pure chance. So that gives the jury an understanding of the weight of the evidence. Because if you have a pool of folks that could potentially be guilty of the crime, and that pool is only 10 people, then a 1 in a million CPI would be statistically significant to help a jury make a decision. If the CPI is 1 in 200 or 1 in 1,000, then that, again, would be a significant, sort of piece of information when deciding what are the odds that from this pool of people that the one who matches the mixture sample is simply matching by pure chance. When you do CPI using alleles in the stochastic range, you'll virtually always overestimate the match. You'll overestimate the CPI statistic. Because any sister alleles that you're not detecting and not using will reduce the odds that the person is a match, if that makes sense. Okay, so this is another area as potentially a Brady violation in the county. In fact, our case was decided on Brady. I think everybody's familiar with Brady because of sort of the timeline that I'm going to go through now. And, I think there's potentially other cases in our county based on what I'm about to tell you that would give rise to a Brady violation. So these two guidelines that we just went over by Swigdam came out in January 2010. Basically, the guidelines, like I said before, it made it so some folks were being included who shouldn't have been, and others, even if they were appropriately included, they were being overestimated. So many of the samples are basically uninterpretable after these guidelines come out. And even if they are included, potentially to a degree higher than they should have been. So the San Diego Police Crime Lab, they didn't change their internal standard operating procedures until April 1st, 2011. So that is a year and 4 months after the Swigdam changed its guidelines. The sheriff changed its guidelines. I'm not 100% sure. I think it's around June of 2011. It was shortly after the San Diego Police Crime Lab changed theirs. And both agencies changed their guidelines, citing specifically the Swigdam guidelines. You may have seen this. This is a letter from the San Diego Police Crime Lab. This was part of my investigation in the writ. But basically, the San Diego Crime Lab, May 4th, 2011, a little bit more than a month after they changed their guidelines, sent a memo to the district attorney's office. And what I've highlighted there, if you could read it, it says, it is likely the new SDPD guidelines will result in more samples that cannot be interpreted due to their complexity and or low level. Of course, leaving open the solution as to what to do with all the improperly interpreted old cases. But even more remarkable than that is even after the San Diego Police changed its own internal standard operating procedures or guidelines in April, analysts continued to provide testimony using the old outdated protocols if the casework was performed prior to the change. So what that means is analysts were, they changed the casework in April of 2011. If the casework was done prior to April 2011, but the trial occurred after, they testified to the old casework. They didn't update all the old casework. And they, at least in my case, did not disclose this to me during the trial. This is some of the testimony that I've taken from the writ. And again, it's a little blurry. Yeah, basically, we had changed for, like, this is the analyst. Like I said, going forward, starting on any casework on April 1st, 2011, we would be using those guidelines. And the analyst, quite frankly, testified during our case that he was using old guidelines. And his testimony, which is even more remarkable, on my case was April 5th, 2011 and April 6th, 2011. So the guidelines had changed just 4 or 5 days prior to his testimony. And even more remarkable is he's the DNA technical leader, so he's the one who changed them. Okay, so one of the things that I wanted to get across to everybody is that this is not just a San Diego deal here. This is a national thing. Texas, based on this in 2015, started a massive mixture review of cases based on DNA calculations. In Texas, they also use a concept called population frequencies when they calculate the CPI. Basically, they take a certain allele and they assign it a population frequency, meaning how often does this allele, just come up in the population. So, for example, in the white community or in the black community or in the Hispanic community, there's different population frequencies. What happened in Texas in 2015 is the FBI released some data that the population frequencies that they were using to calculate the CPIs were a little bit off. So Texas started a review with the new population frequencies. But what they found out is that the SWIG dam changes actually affected the CPI statistics way more than any population frequency changes did. And so that alerted them that, wait a minute, there's another problem here with DNA. The Texas Science Commission here wrote up a long report about it. Basically, saying that, here, the laboratories explained that the significant statistical changes were not attributable to FBI database corrections, those are the population frequencies, but rather to the fact that the evidence in these cases had been originally analyzed before the laboratories made certain important revisions to their mixture interpretation protocols to comply with the recommendations made by the Scientific Working Group on DNA Analysis Methods. So that's basically what happened. This is like a 30-page document too, and I have copies of this. So they've discovered all kinds of issues with improperly interpreted mixture samples. There's more of that here. And so this is another one this is American Society of Laboratory Directors, I think. And this is in Broward County, Florida. Their lab was censured for basically inappropriate use of the statistic known as the combined probability of inclusion to calculate statistical significance of occurrence of genetic profiles when allelic dropout is known or is suspected to have occurred, and inappropriate consideration of submitted known reference samples to determine loci that will be selected for statistical purposes. So these are the exact same things that happen here in San Diego. It's seriously, it's the same exact issue. They're basically doing suspect-centric interpretations and considering alleles in the stochastic range. So it's Texas, now it's Florida. It's also Washington, D.C., where they've discovered this problem. I don't know if I have to go over this with you, but this is on my PowerPoint. goes over what was going on in Washington, D.C. This practice of suspect-centric interpretations and using low-level data inappropriately was happening, endemically across the nation in crime labs all over the country. To date, I only know of one person who's had their conviction overturned because of this, and that's my client. So obviously, there's more. Okay, there's more people out there. There's more people in cages right now who, would be affected by these. And that's, and we'll go into the conduct of the district attorney's office too, because that's kind of relevant as to what we need to do as a criminal defense community about it. This is the PCAST report, which is the council that advises the President of the United States on, the state of forensic science. And even the PCAST report in September of 2016 mentions this as an issue, as a national issue. I wish this wasn't so blurry. I'll just read the summary. In summary, that's that middle part. The interpretation of complex DNA mixtures with the CPI statistic has been inadequately specified and thus inappropriately a subjective method. As such, the method is clearly not foundationally valid. And the reason they're calling it inappropriately subjective is, again, the suspect-centric process of interpreting data. When you look at the sample for inconsistencies before you decide which genetic markers are appropriate for comparison, you're making a judgment call. You're making a subjective judgment call. The expectation, in my mind, when you tell a jury a CPI statistic is that that statistic is an objective fact. And based on these procedures, that statistic is not an objective fact. And it's just a statistic that was generated based on subjective decisions made by a human. And so that's what the PCAST problem with it is back in 2016. I only mentioned the date just to clarify which president this came under. Okay, so you got, many of you may have gotten a letter saying, hey, there's an issue, we've identified these 254 cases, or maybe I think they identified your specific case, and so the DA's office is encouraging you to come in and talk to them, which isn't a bad idea. But you should know this timeline before you cooperate and collaborate with the district attorney's office. You should know who you're dealing with. They found out about this in May 4th, 2011. We have a memo that proves this. They were notified that there are changes and that the changes would result in more samples that cannot be interpreted due to their complexity and or low level. So 5 years go by, nothing. Nobody got notified about this. They didn't review any cases. There's all kinds of scientific literature that supports that not only was this a change in protocols, but a change that was implemented because of inappropriate work. And so that's well documented in the scientific literature. So they say nothing to the community about this. Then, in my case, the judge grants an OSC on June 20th in 2016. If you know anything about habeas litigation, what an OSC means is that the judge agrees with your legal points and says, you're absolutely right. If what you allege factually is true, not saying that it's true, but if it's true, I'm going to grant your habeas relief. Now I'm going to issue an OSC, and it's your burden now to prove the facts that you've alleged. So essentially, the OSC was telling the district attorney, hey, if this is true, there's a problem here. So then, August 18th, more than 5 years after the DA's office was notified, Bonnie sends a Dear Counsel letter. I think I have that here, where she basically says, you might remember this letter when it came out. If you handled a case involving a DNA mixture prior to 2010 that you believe could be impacted by these mixture interpretation guidelines, Please feel free to contact the Conviction Review Unit. And it gives an email address. Well, this is what they argued in the writ work that I did. I just find this so fascinating. Some of the arguments that they were making, they never surprised me as to how creative they can get. They were basically saying that the old opinion of the analyst under the outdated guidelines was still valid. To reconcile his opinion under two different guidelines, Monpetit has explained how both can coexist in his declaration. Under the more restrictive or conservative guidelines that were in place from 2011 to 2015, the lack of data renders an inconclusive finding. Under the less restrictive pre-2011 guidelines, Dominguez is a possible minor contributor because Monpetit can conduct a statistical inclusion analysis. Nothing in the new guidelines prevents a criminalist from testifying it's their pre-2011 results or opinions, as the new guidelines did not invalidate opinions rendered under the formal guidelines. So this is just a real brain stretch when you try and think about logically what this means. They're saying that the analyst can appropriately say both that a person is included as a contributor and at the same time say that it's inconclusive whether they are included as a contributor. And both those are forensically valid. That's essentially what they argued and lost in the writ hearing. So then we get the first Dear Counsel letter. October 6, 2017, the court grants the writ in my particular case. There's a pretty long opinion, and it's worth reading, I think, because the judge in the case did really understand the issues and gave a great summary of the issues. But the district attorney's response was then they decided to do a mixture review, which took place thereafter and was announced on January 22nd, 2018. And this is really great, actually. I'm glad they did it. And, I think some of the folks over at the district attorney's office are great lawyers and great people, and they took it up and they said, you know what, we're going to do something now. And they finally did. Unfortunately, in my personal opinion, it's a little bit late, but I'd rather them do it late than not do it at all, obviously. So then, this is the Dear Counsel letter. This is kind of what we're all here about. Maybe you got one of these or know somebody who did. And even if you didn't get one of these, I still think it's an important issue for any criminal defense attorney in here, because you might be contacted by somebody who asked you about it, or you might have a case that's affected by these guidelines that wasn't part of the review, and that's very possible, and for specific reasons. So again, they identified only 254 cases, but I suspect there are more. I suspect in this county alone, there's probably more than 1,000 that are affected. Orange County, I think, had the same problems, and if you multiply, whatever our population is here in the county, what the ratio is between our population and the nation, and you think about, who knows how many crime labs were using these techniques. The numbers are huge on this one, I think. I think only time will tell. There's really no way to tell how many people were affected until, all the communities get together and start reviewing cases, which hopefully will start soon. Some of the limitations of the Dear Counsel letter is they only reviewed cases that went to trial. Okay? That's a huge distinction, because as criminal defense attorneys, we know, I find it to be an unfortunate fact, but it's a fact that a very small percentage of cases go to trial. Most cases resolve in a plea. I think it's very understandable to present a client with some DNA evidence, and even though they're innocent of a crime, they're compelled to plead guilty to a serious felony because they believe there's DNA evidence against them, and even though they can't explain it, they understand the realities of the situation. So it's a very real possibility that many guilty pleas were induced by DNA evidence that's not supported by science any longer. And so to limit the review to only cases that went to trial misses a huge portion of cases that could be affected. So understand that when you got a letter about one of your cases, that's great, but think about all the cases that didn't go to trial, not just for your office, but the few hundred or thousand criminal defense attorneys we have here, the San Diego Public Defender's Office, alternate public defender's office, appointed clients. I mean, if this started in 2003, some of the lawyers are probably dead now that handled some of these cases. And so what happened, plea cases, trial cases. So, so the review was great. I'm so happy they did it, but understand that it has limitations. The DA's attitude, I hate to be nitpicking, but in their letter they state that even though they've identified these cases, they don't anticipate finding a significant change in any case, which is okay. I mean, I don't know why they put that in the letter. It's just a reflection of their attitude towards the issue. And this is just my opinion for what it's worth. It took when I think the issue was rather obvious on May 4th, 2011, when they got that letter. And I know when I learned about the issue, it was pretty obvious to me. But the DA did absolutely nothing until the court told them they had to reverse the murder conviction. And so again, I just think that reflects on their attitude. So what do you do to respond to the letter? I believe, and again, I'm not really citing any law or ethical rule, but I think the first thing that has to be done when you receive a letter is to notify the client. I think absolutely the client, you might not have an interest in pursuing this work or the ability or the time. Or you might not have the resources because the client doesn't have any money or whatever. But the client deserves to know, in my opinion, if they're on the list. And even, again, there's just other issues with unidentified cases. But if you get a letter, it's my opinion that the absolute first thing you need to do is write a letter to your client and enclose a copy of the letter from the district attorney's office to notify the clients that they're on the list. Generally, I just think and I apologize for getting into some of the opinions here, but it is part of it. I just think we need to put some media pressure on the district attorney's office and the public defender's office, because I think they have a duty here as well to understand whether guilty plea cases are affected. It's just sort of an untapped resource as far as potential cases that could be found. If you get a letter, if you read the letter, it'll tell you have the ability to contact the conviction review unit to request a recalculation. The two deputies that are in charge of the conviction review unit, Brent Neck and Bryn Curvin. I know I've definitely criticized the district attorney's office, and I don't apologize for that. But I will say that these two are very receptive to hearing you out. And if I was going to call anybody and work with anybody at the district attorney's office, it would be one of these two folks, because they actually do care about wrongful convictions, and that's their mission over there. That's the assignment that they've been given, is to review wrongful convictions. So these are the two people at the district attorney's office that are, if you decide to contact and work with the district attorney's office, which there's nothing wrong with that, if you have some trust and a relationship with them, I would recommend getting in touch with these two folks. If you want to do a recalculation of the DNA evidence, you can call their paralegal, Tamara Clark, and I put a phone number up here as well. The other option is to just ask for a duplicate lab packet and get your own expert. Of course, this costs some money. If it's an indigent client, I think that it hasn't been done yet, but I think that indigent funding for this might be available if enough of us get together and file that motion. I'm sure all of us have filed an indigent funding motion at one point or another. I think that hiring a lawyer to review somebody who's on the list is probably a ripe new indigent funding motion that we could all file. If you do recalculation either through the district attorney's office or if you do one on your own, you could you could ask for a stipulation for habeas relief from the district attorney. Sometimes they do that. You know, I wouldn't be too excited about that because they don't typically reverse convictions quite so easily. It might take some convincing, but that's an option as well. If you can't agree with them, then the only option for you is to file a habeas petition for your particular client. They're, you know, a pain in the butt to file, but you know, I'll give you the starting law, and of course there's tons of law on this, on habeas, but that would be the remedy, is to file a habeas petition. The grounds for the habeas petition would be Penal Code 1473. Basically, this actually only got enacted in January of 2015, the new section here, which says false evidence includes opinions of experts that have either been repudiated by the expert who originally provided the opinion at hearing or trial, or that have been undermined by later scientific research or technological advances. That was added in January of 2015. If you do file a habeas, the other issue that we haven't discussed at all is that the DNA evidence, in order to get relief, has to be material or probative. And that's right here in the code, and that has been defined as material or probative if it is of such significance that it may have affected the outcome in the sense that with reasonable probability it could have affected the outcome. It's the exact same standard in Watson, and it's the exact same standard for, you know, ineffective assistance of counsel. It's the reasonable, you know, probability test. Is it reasonably probable you would have got a different result without the evidence? So you should be familiar with that test. So that's it. If you have any questions, I'm super happy to help. I've got my phone number, my email, and I think you're going to email the packet. There is this link is a link to the entire habeas case, including all filings, all transcripts of the habeas petition. I set this link up to share everything. All the exhibits that I've gone through, and I just picked out a few exhibits. There were 50 or 60 exhibits, including maybe 20 or 30 different forensic journal articles, as well as forensic reports from the lab, and all kinds of material. So if you get yourself in a quagmire where you're dealing with this issue, and you want some, if you want the file and it's already been done, you can have my entire file on the case. It's right here. All of it has been filed with the court, so it's all public, record. So it's not giving you anything that isn't available at the courthouse anyway. But it's all available electronically at this link. So that's it. I think I have 2 minutes left, but if you have any questions, do you do questions? I don't know.
Yeah.
The second code is 121. The second code is 121. The second code is 121.
Question? Yeah. I've got a question.
Yes, sir.
Over the last 15, 16 years plus, ever since that 2003 date that you were talking about, where we started using more and more of the DNA stuff, I have not tried a case where DNA was any kind of a major component of the case.
Yeah.
And the cases that I've negotiated pleas on, and again, within that same time frame, perhaps 4 or 5, again, I'm just like at the top of my head, might have had DNA evidence that was significant, but never determinative in my mind of the guilt or innocence of my client. It was another brick in the building of the wall.
Sure.
They almost always had some of the circumstantial evidence, some direct evidence or whatever. And so should I have cause for concern that maybe it makes sense to look back at those 4 or 5 cases, whatever they may have been, to find out whether or not I should think about doing something that you suggested about evaluating the cases. Again, even though 1, they never went to trial, and 2, they were never anything more than another brick in the wall of the conviction. Again, how concerned should I be about whether or not I might have, I can't say I did anything necessarily inappropriate, but whether or not that I might have had some clients that had convictions that, based upon some new science, would suggest that maybe we should not have pled at all.
So the reasonably probable test applies to a verdict. without a verdict, how are you going to tell whether the evidence was reasonably probable? How are you going to tell if you would have gotten if there's a reasonable probability you would have gotten a different result? So I'm afraid in plea cases, there might be a different analysis for which I am not familiar. Okay. The issue, though, is, if we were going to apply that standard to plea cases, just to sort of hypothetical out, a situation, the evidence isn't material probative if it's quote unquote the only evidence or the best evidence. It just has to be material. It just has to be important.